Welcome to INAN's Advocate. INAN's Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Anjali Talreja. She completed her LLB from Motherhood University, Roorkee, Uttarakhand in the year 2021. She is currently associated with the District Legal Services Authority as a Assistant Legal Aid Defense Counsel. She is assigned to the Esplanade Court and she handles matters triable by the CJM Mumbai. Today, Advocate Anjali is going to speak on pre trial detention in India, the dynamics of custody and remand. So, without wasting further time, I would request Advocate Anjali to commence with her lecture. Thank you.
As law students and even general people, we have this misconception that if a person is arrested on a Friday, after 5 pm, he'll be produced before the magistrate of the jurisdiction on Monday morning. But this is absolutely incorrect. There are provisions in the criminal law procedure which makes it very evident that a person who is arrested has to be produced before the magistrate in 24 hours. The government of India has to protect the dignity and liberty of every citizen. However, there are certain citizens which are deprived from their liberty because they are custodial prisoners or involved in any crime. The Constitution of India guarantees several rights under Article 20, 21 and 22 to the prisoners and persons in custody. For instance, right against inhuman treatment by police, right to get free legal aid, right against handcuffing, right to fair and speedy trial. So, after receipt of a report of a crime, a police officer immediately arrests the suspected person to prevent him from destroying any evidence or tampering with any witnesses. Once the police officer takes the respective person in custody, this custody is called as police custody. In landmark judgment of D.K. Basu versus State of West Bengal, there are certain guidelines given by Honorable Supreme Court for arrest and detention. The police officer carrying out the arrest should bear accurate details of his position, his name and clear identification with his designation, and he must be recorded in the register. Police officer at the time of arrest must prepare an arrest memo which is to be signed by the family member of the arrestee or any respectable person of his neighborhood. This person who signs this memo in our court language is called as punch. Person arrested must be aware and educated regarding the rights of his detainment at the time of his arrest. An entry must be made in the diary at the spot with name and specifics of police authorities in whose care the arrestee is. Arrestee must be examined by a doctor at the time of arrest and report must be prepared that whether the arrestee was previously injured or had any minor or major injury marks before the arrest. The said memo of medical report is to be signed by the police officer and also the arrestee. All these documents like medical report, arrest memo, along with remand report, police diary is to be sent and produced before the magistrate. But when? Because we believe that the courts are often shut on Saturdays and Sundays. That means he'll be produced after 2 days. But when? Because we still assume that the arrestee will be produced after 2 days because of the government holiday. That is what we believed so far, but this is incorrect. Section 67 of BNSS along with Article 22 of Constitution says that no person can be detained in police custody for more than 24 hours without being presented before the magistrate. This excludes the reasonable time of travel. The same provision was in CRPC as section 57. Yes, judges are always working even on the holidays. That means we always have a holiday court working specially for this provision because of this provision of the criminal procedure. Now, a police officer had 24 hours with the arrestee, but in a lot many cases, these 24 hours are not sufficient for the investigation. Reasons can be property stolen is not recovered, weapon is not recovered, the co-accused is not traceable, and there are many more such reasons. Now comes section 187 of BNSS, which was section 167 of CRPC. This section talks about what if investigation is not completed in 24 hours? What if a police officer requires more time with the accused or suspected person for further investigation? So can a magistrate extend his police custody? Yes, a magistrate can extend police custody for a term not exceeding 15 days in whole or in parts. But are 15 days also enough? In such situation, BNSS has given us an option that a magistrate can extend the police custody and give time for investigation up to 60 days in certain crimes and 40 days in certain crimes. 60 days is for the crimes where punishment is life imprisonment, death, or punishment of more than 10 years, and 40 days for all the other crimes. The maximum period for investigation in 60 days and 40 days, but maximum period for filing of charge sheet is 90 and 60 days respectively. As per this section, accused has to be present in person for extending the police custody, and at the time of extending police custody, the magistrate must record the reasons for his extending this custody. Now, all this time, all we did talk about is police officer, his investigation and a magistrate's role. But when did the role of an advocate or legal representative comes in picture? Remand is a legal process after arrest. When the accused is presented before the magistrate, the advocate's role is to satisfy the court that further police custody is not required. Let accused be granted judicial custody, and accused can only be granted police custody only and only if the investigation is not possible without him. If investigation is possible without him, this is a well settled principle held in many judgments like Hammurabi versus State of Gujarat also, that if accused is necessary, then only keep him in the police custody or else grant them judicial custody. Now, what is judicial custody? Judicial custody means the suspected person or arrestee is presented before the court and magistrate passes the order of judicial custody, which means now the arrestee is responsibility of the court and not the police, and he will be transferred from police lockup station to jail. Why an advocate emphasizes on JC is because then only we can apply or seek for bail or any other remedy for the accused. For appearing on behalf of the accused in remand, the advocate has to file a wakalatnama, and in general practice we often keep 2 wakalatnama in hand so that if we are seeking bail in any other court for him, we can quickly use the other wakalatnama. The accused person gets the right to speak to his advocate at that period of time, and thus we can ask questions to him, communicate, and we can get more idea of what has exactly happened. In practice, usually 14 days of judicial custody is granted to the accused person, and once judicial custody, now the usual procedure of the court happens via video conferencing only. Hardly they are being produced before the magistrate. Now, IO, the investigation officer, has to file a charge sheet in 90 or 60 days as the case may be. In between, the accused can seek bail from the court. But if the investigation officer fails to file the charge sheet in the given period of time, the accused gets automatically eligible for a default bail. Right of default bail is a part of Article 21. The same was reiterated by the Supreme Court in Fakre Alam versus State of UP in 2021. This right becomes due exactly after the elapse of the period of 60 or 90 days respectively in the cases if charge sheet is filed exactly after 2 days of expiry of that period, still the accused is eligible for this default statutory bail. Once an accused is granted bail, that does not mean he is exempted from investigation. Bail only ensures that the accused is not kept in custody during the trial or investigation. It does not bar the investigation even if charge sheet is filed. Police can further investigate even after filing of the charge sheet. There is one more type of remand, that is transit remand, which means temporary custody of a person or a suspect by a court to facilitate their transfer from one jurisdiction to another. If a person is arrested at one place different from where the alleged crime took place, then he needs to be transferred to the court which has jurisdiction of the case. In our regular practice, this is called tabe pe lekar aana. The Supreme Court has time and again emphasized on not arresting people or suspected person just because you doubt that person. There are other provisions in BNSS like section 35, which was section 41 earlier. This section says that if a police officer believes that the arrest is not required, then he can issue a notice to the suspected person for appearing before him and the person has to comply it. While investigating him, if the police officer believes that yes, the detention is of utmost important to get this investigation and done, then he can record his reasons for arrest and why it is necessary and then can arrest the person. In landmark judgment of Anish Kumar versus State of Bihar, because of the widespread of misuse of section 498A of IPC, which addresses dowry related harassment, the Supreme Court is time and again emphasizing that use other ways of investigating rather than putting people in detention. There are a lot many challenges and criticism have been constantly received because of this pre-trial detention. The jails are very crowded. 75% of the jail prisoners are under trial. Their living conditions are very poor and they have been granted bail, but the situation is such that it is very difficult for them to fulfill this requirement of bail. The requirements such as bringing a surety of the same area, same place, or arranging cash from inside of the jail because they have nobody outside of the jail. There are very poor health conditions and violence. The detention of accused violates their fundamental rights, and also it is a cost to the state, and this gives the direct exposure to the criminal network to them. To conclude, pre-trial detention is a necessary yet delicate component of criminal justice system intended to ensure for trial and protection of societal interest. Thank you.
Anjali, thank you very much. Even though it was a short, but it was a really crisp way in which you had mentioned about the detention, remand, and I think the more important thing which you have covered in your lecture is the misconcept कि Friday को पकड़ा तो Monday को ही हाजिर होगा. Because lot of people are not aware that there are holiday courts, person has to be produced over there. So I think it was, though it was a short, but it was a very nice presentation regarding topic. Thank you very much. A small token from Hammurabi to you.